Okay, so then please take your seats and we will start immediately giving Alexandra Troitskaya the chance to explain us the organization and the function of the judiciary in the Russian Federation. Afterwards, as always, we will have the chance of discussing with her about these topics. Please, Alexandra, take the floor. Thank you.
Yes, and first of all, let me thank the organizers for inviting me to have a talk. It's an honor for me and a great possibility to talk about judiciary system in the Russian Federation. And the starting point is, not surprisingly, the Russian Federation is a federation. And it's a very complex federation. You can see it consists of 85 entities. And what is more important, maybe, that they have different status, different legal status, because they're not all like lender in Germany or states in the USA. These entities are of 6 different kinds. I mean, republics, areas, districts, federal states, and some territories with autonomous status. And there is a real federation. I mean that there are self-rules and shared rules as main principles of federation. And there are 2 levels of public power, the national level and the level of the entities. We call them, by the way, subjects, subjects of the Russian Federation or federal subjects. And besides that structure, and maybe because of that difficult structure, there is no special judicial system for the subjects. And if I had 3 minutes, I could just say that there is a unified judicial system in the Russian Federation. But as I have little more time, the story will be a little longer. And first of all, we can see that we have an impressive normative regulation concerning the judicial system. Of course, we have our constitution, and it contains all necessary norms concerning the judicial system and its independence. And there are several laws, and the most important laws are federal constitutional law on the judicial system and federal law on the judges' status. And according to our constitution, there are 4 forms of justice: constitutional, criminal, civil, and administrative. And the list is exhausted, so these 4. And you can see courts for these forms of justice. You can take a minute to see that constitutional justice is realized by constitutional courts, of course. It's a civic law of family, so specialized courts. But we have no special administrative courts at all. And that's why courts of general jurisdictions, they make decisions on criminal, civil, and administrative.
Sorry, are there more than one constitutional court?
Yes, I'll tell about it. Okay. It's courts, no mistake, that's right. And on the contrary, we have very special courts, which we call arbitration courts, and sometimes it can be translated like commercial courts. And they also can resolve civil and administrative issues. Why special arbitration courts? The main reasons are historical, because in the Soviet period we had no private sector. So for resolving the disputes between state-owned companies and between state-owned company and the state. No need for special court. And in post-Soviet period, of course, we have private sector, and the idea was establish the special courts to promote market economy and to resolve these kinds of disputes. It's just like a little digression. So, 4 forms of justice, and we had 3 kinds of courts. And the problem was that 2 branches of these courts sometimes consider just similar cases between different subjects. And the problem was that some decisions were not coherent, and the result was abolition of highest arbitration court of the Russian Federation. And it was last year, and it's, well, a great reform. It was an amendment to the constitution just to remove high arbitration court and every mentioning of it. And it's a very difficult story for us because the highest arbitration court, it had more confidence, not especially from regions, but from all citizens, and we have removed it. But I won't go in detail about this story because it's not the question of federative structure. And what is sufficient for us to see now is the whole judicial system of the Russian Federation. And you can see that there are constitutional courts which are Constitutional Court of Russia and constitutional courts of subjects of Federation. And they are not in the system by themselves because they have different jurisdictions, and you cannot appeal decisions of constitutional courts of subjects to the Constitutional Court of Russia, and of course vice versa. And why they exist? Because every subject of the Russian Federation has its own constitution or its own charter. So these courts exist. And you can see that 2 jurisdictions are with us now, but the Supreme Court of Russia is the main court for courts of general jurisdiction and arbitration courts as well. And what is more important, maybe, that only 2 kinds of courts are courts of subjects of the Russian Federation, and other are federal. And the system, that's why I can call it united, because our constitution said that the judicial system of the Russian Federation shall be instituted by constitution itself and by the federal constitutional law. And according to this federal constitutional law, judicial system consists of federal courts and courts of subjects which are constitutional, and courts of subjects which are magistrates, or if we translate literally, courts of the peace. And that's why only 2 stars here on this slide. So almost all courts are federal. And what does it mean? It means many things. First of all, it means unified status of the judges. It means federal rules concerning their organization and functioning. And it means Russian language as the language of proceedings. And just not to return to this question, you can see the article from our constitution, And it's exactly the article about 6 kinds of subjects. And you can see that they have to be equal, but it's not the whole idea, because some subjects are more equal than others. And it's the case for republics. And you can see that the republics shall have the right to establish their own state language. It means not in replace of the state Russian language, but in addition. And they have realized this possibility. And now in courts of republics, which are situated in republics, you can use both languages, Russian or another state language. But it's only for republics. And in all other courts, you can use only Russian or, of course, your own language, but with translators. So the proceedings, main proceedings, they will be in Russian. And here, an interesting thing, because you can see that these courts called courts of subjects, and these courts as well, but they all are federal. Okay. They all are federal, so the same rulings about them. And concerning the status of all these courts, there is a general understanding in the Russian Federation that the main principle is the independence principle, and it means 2 things, institutional guarantees and personal guarantees as well. And concerning institutional guarantees, we can say that, okay, they exist, because there is a separate branch of courts which are separate from executive, for example. But there is an important remark, because courts of general jurisdictions, they coincident with administrative and political entities. And arbitration courts are not tied to territorial division, and maybe that's why they were more independent than courts of general jurisdiction. And, you know, it's a strange decision, because if they all are federal, why to tie courts of general jurisdiction to the territory? You can violate their boundaries, and it hasn't been made. And the most problematic question is about personal guarantees, because according to our laws, there are, of course, some norms which could provide for such independence. For example, some prohibitions for judges to have other state or municipal posts, or to take part in political action, or be a part of a political party, and so on. And there are also some guarantees for their activity, for their justice. For example, procedures of justice, which all are federal, and there is a ban of intervention to the justice, and there are rules of appointments and dismissal of justice, and there are bodies of judicial community, etc. But the idea is that these guarantees, they do not work as it was supposed. For example, we have several bodies of judicial community, such as Congress of Judges and Conference of Judges of the Subjects, Council of Judges of the Russian Federation, Council of Judges of the Subjects, and also general meetings of judges of the courts, and qualification collegia of judges and examination collegia of judges, both at the federal level and at the level of the subjects. And the main problem is about procedures of appointment of judges. And I'll try not just to describe it, but also show its problems. And you can see that 4 last bodies of judicial community, they take part in the procedure of appointment of judges. Because several bodies take part in this procedure, and not only Presidential Commission, President himself, but also some of the bodies of judicial community, such as High Qualification Collegium, Qualification Collegium of Judges of the Subjects, and Examinations Commissions of both levels. And here is the status of High Qualification Collegium. And the most important thing that its main function is the selection of candidates for the highest and certain intermediate courts. And this body presents its recommendation to the president. And this body consists of 29 persons. And it's important to figure out that 18 of them are judges. And there are also 10 representatives of the public appointed by the upper chamber of parliament. It means Council of Federation. And 1 representative of the president of the Russian Federation. So here it is. Even in this body of judicial community, there is a representative of the president, and it's important. And Qualification Collegium of Judges of the Subjects, they have a similar function on their level, and they have 21 persons. And also, they consist of judges, representatives of the public, and representative of the president of the Russian Federation. And you can notice that it's not representative of the executive body of the subject. It's still representative of the Russian president. And besides that, Qualification Collegia, they have consultative functions. So you can see that here are present some judges of the subjects and representatives of the public from the subjects, but it's not the great influence for the procedure of appointment of judges for them. And the main critique about members of Qualification Collegia was that, of course, they have judges, and besides that, they have some strange people. And public representatives, why they are here? Because the idea was to avoid judicial corporativism. So that's why we added them. But who they are, we have such requirements that they are citizens of the Russian Federation, of course. They are 35 years. It's great. They have living experience. And they have high law education. They must be without dishonorable acts, and nobody can say what does it mean exactly. And after that, they must be representatives of a public, so it's not heads, it's not states or municipal services. They mustn't be heads of organization and not advocates. And you can explain to yourself how you would like to explain it, not be an advocate, and a notary as well. And representative of the president of the Russian Federation, it's much more simple. It must be citizen of the Russian Federation or government service. So the main question are these people really best equipped to choose the judges? And there are some reports about problems with their independence. At the first glance, the qualification collegia, they consist majority of judges, it's okay. And presidents and deputies of presidents of the courts mustn't be members of qualification collegia. So judicial hierarchy will influence their decisions. And there are also some requirements concerning quorum. But we can find easily some reports which tell us that procedures of choosing of judges are not free from some influence from judicial hierarchy, especially president and deputies of presidents of the courts. And just because this pressure is not formal, it's very difficult to prove it, and it's very difficult to resist it. It's not, well, in media, it's just some people tell to other people. And the procedure of appointment of judges, it's very complex and long procedures, but two main stages, and it could be a third supplementary stage, because first stage is preliminary selection, made, of course, by qualification collegia, and after that appointment by the president. And in the case of high court, it means Constitutional Court of the Russian Federation and the only last Supreme Court, we need also approval by upper house, but here we can also we cannot also see here a great influence from the subjects of the federation for two reasons. First reason is that upper house usually approve those candidates which were suggested by the president. And the second reason is the difficult question about, are members of upper house really representative for the subjects? It's another and also long story. And here are requirements for candidates, for judges. Those who want to be a Russian judge must be a Russian citizen, must reach the age of 25, have a degree in law, and because of changing of our educational system, we have moved to 2 levels of education system. It was a great discussion, could the bachelor be the judges? And the answer was not, only masters of law, not bachelors. And also there is a requirement about 5 years of professional legal experience. And there are no special requirements which legal experience exactly. But it seemed to us that preferable professional legal experience could be either in courts, in administration of courts, or from executive branch of power, from bodies which enforce law. And they are in more preferable position than advocates and notaries and private lawyers. And there are also some requirements for candidates, which means obstacles to present oneself to that position. And the main problems you can see not with foreign citizenship, for example, or criminal record or prosecution, it's self-evident. But the main problem is about close relative or relative in law of the same court chair or deputy chair. So the problem is that it was understood very broadly. You have to have no close relative in any court, not just in the same court, and it's important. Of course, maybe because it's Russia, you not have problems with alcohol, it's okay. But there's still some questions about, are these requirements sufficient for judges indeed? And besides that, of course, we have exams. And the problem about exams that there is no strict procedure for exams. And there are some standing order which were issued by examination commission by themselves. And you can see that when you come to exam, you have to put some card, just as in the university for the students. You have not less than 2 hours for preparation, and usually it's 2 hours exactly. And you have 3 theoretical questions in different fields of law, and I have seen these theoretical questions. They are okay for people who have higher education in law. But you also have to resolve 2 cases and to prepare some documents for a mock case, and all these for 2 hours. And after that, it could be also additional questions. And our main officials, they told sometimes that they themselves couldn't pass these exams nowadays. They are judges for a long time, okay, but now it could be problematic even for them. And of course, there is a strong criticism about this examination because time is insufficient. And the main problem that there is no universal approach to evaluation, and the decisions are taken behind closed doors, so you cannot hear why grades are that or this. And problem for preparation for this exam is that you have no textbook or just case books, something like that. And there is no unified standard for this examination in several subjects. So it can depend on the subject. Will exam simpler or harder? And request to qualification collegia can be posed after the examination if it was good. And there is also some important point, because besides of biographical details and documents certifying degree in law and employment record and health conditions and exam results, you have also posed a record of service covering last five years of employment, and it is signed by your boss. And if you were a judge, it's court president which signed this document of service. And he can tell the story about the quality of decisions made by this judge. And there is no criteria to define whether the quality of decisions high or low. And for other candidates which are not from the judge corpus, wording of document also is very important. And there are some refusal decisions about candidates because of wording in these documents. For example, that somebody has lost his interest or expressed discontent in prosecution activity. Okay, he has lost his interest in prosecution activity. He would like to be a judge. It seems to be okay, but no. It's a person which has lost his interest in something. It doesn't convenient at all. And qualification collegia, they check the documents. They check them by themselves or with the help of law enforcement agencies such as Ministry of Interior or Federal Security Service. And there is no clear procedures for this checking. And there is also many questions about candidates' experience and very broad criteria for approving or for denying these candidates. You can see some examples for refusal. And after that, chair of the court also has the possibility to avoid this candidate, but his veto is suspensive. It can be overridden. And after that, there is a submission to President Commission, which can choose judges, and a recommendation of qualification collegia has no judicial force for them. And our constitutional court said that it's okay because it's a margin of appreciation of our president to appoint judges, and there is no problem. So there are some important questions about term of office. And the main problem is 6 years with possibility to reappointment for chairs of the courts, because it can be also an object for pressure for them if they want to be reappointment. So here are the main problems with this main procedures of appointment, and several words about autonomy of subjects concerning judicial system. Here, two kinds of courts, which are of subjects. But there is a federal law regulating status of judges of the peace. And you can see that this federal law is very detailed. And besides that law, there is also a federal budget for supporting these judges. And also federal procedural rules and federal information system and decisions in the name of the Russian Federation. So the main question is if these courts of the peace are indeed subjects. At the same time, many of people are concerning about their dependence on the regional bodies, and are suggesting to make them federal without any exemptions. And subjects to constitutional courts, they are, of course, courts of subjects, but the main problem that to create these courts it is a right, not a duty for subjects. So they exist only in 16 subjects now. And appointment of these judges is the duty of legislature or the subject. And the procedure for appointment is quite different from the whole federal procedure. So we can see two main problems about this court. it's unequal possibility of citizens to go to these courts because they exist only in 16 subjects of the Russian Federation, not in others. And also unequal status of judges. And somebody can say that it's a problem, unequal status, and dependence of these judges of the subject agencies. And the main cause that I state so cautiously about the procedures of appointment of judges, that they are about the influence of the national bodies, especially President of the Russian Federation, and there is no problem. And when we talking about their dependence on the subject agencies, we can see here a problem. So we must choose the evil. And as conclusions, I can say that there are several problems, and they are in close conjunction, and we have to resolve them at the same time, I guess, because it's not only the problem of unity or diversity of judicial system, and we can say that judicial federalism is absent in our federation state, and also it's inconsistency of judges or the peace status, and also the problems about their appointments. And there are different evaluations in our country. Somebody can say that we have a great success in our judicial reform, and somebody can say it's complete disaster, and our judicial system is destroyed totally. But maybe the truth in somewhere in between, and we have a great way, but we also have to resolve all these problems. Thank you.
Thank you very much, Alexandra, for this impressive presentation on the, I would even say, the difficulties of the Russian Federation, not only with regard to our topic in reconciling unity and diversity in a territorially extremely compound and differentiated system with 85 subjects, but also with regard, and I think this was very important in order also to separate this topic from what we had heard before, despite the difficulties with Islamic Sharia courts and so on. But here, the huge political influence, which is a problem still, as you pointed out, which in part probably is overlapping, as you have pointed out with your example on the representative of the President of the Russian Federation, overlapping actually with the federal topic as we are talking about here. And so even the determination of details of the federal system by the Federation, although they are called by name courts of the subject, as you have pointed out, or they are even in substance courts of the subjects, as you have said, with the peace courts, but then there was this impressive list of federal laws regulating actually each detail of these subject courts. I also think that it's very important that you guided us through the very details of appointment procedures and the qualifications, exams, because we are talking here about a career system by contrast with the common law systems we have been talking about before. And of course, in a career system, it's very important whom you choose and by which means you choose them, and also what is the qualification requirements, the political influence, again, which can be exercised. And I'm talking for so long because I will tell you very similar things tomorrow, probably because, of course, in the former Yugoslav socialist states, there is a similar thing. And I think this is also, and again, here's a parallel, also justifying what was also new in your presentation compared to the cases we have seen before, which is these judicial self-governing bodies, these qualification panels looking into the candidates' qualifications and running the exams, because they were thought to be counterweights to politics. But then, of course, we have to look also what is happening in practice. So I've talked for so long because I wanted to give you time for thinking of questions. Are there any Questions from the floor or comments? Matthias, this is very good. Thank you.
But perhaps I should give the President and somebody else. I'm always the first.
No,
here.
it's not a...
Thank you very much, specifically for your openness and critical approach. It started with the first slide. I carefully observed that you not even mentioned Crimea on this slide.
I can say that 85 entities, including Crimea and city of Sevastopol.
But it was not shown there. Sorry. I appreciate it very much that you are so open and so critical. I have some questions. The first is, what about the jury courts? There have been difficulties in the first run concerning the decision on the death penalty by the Constitutional Court. At that time, in the first decision, it said there have not been such jury courts in all subjects of the federation, and only in 2010, the last subject was Chechnya, established these courts. Is this within the competences of the subjects to establish these jury courts? Would be the first question. The second question concerning the examination. The examination, which you showed us, very impressive. Is it always done in Moscow or also in other parts of the Russian Federation? The third question: what happens if a murder is committed, let me say, in Chechnya? Is it possible to judge it in other parts of Russia, or will the person who committed the murder be judged in Chechnya? This is also, in a way, sort of, let me say so, in a broad sense, a form of federalization of a system. Did you get the question? No. When a person commits a murder in Chechnya, will he be judged in Chechnya or in other parts? This is, I think, a very important thing. And the last thing here, I would perhaps it's more a comment than a question. The question of the influence of the executive on the composition of the courts. In 2014, in June last year, there was a big reform also of the Constitutional Court, and in former times, the president always had to appoint a new constitutional judge within a given time, two months' time, I think. And now this has been abolished. He's free to appoint a new judge or not. There's just a quorum. There are 19 judges at the Constitutional Court, and the quorum now is 13. If there are less than 13, then he has obliged to appoint a judge. If they are not, if there are 13 or more, he is not obliged. So he can manipulate the thing. And he can manipulate them more as a judge who reaches the age of 17 normally has to retire. But if he retires, the figure of the judges will fall below these 13 judges, then he can stay in the office. So in general, they can stay there forever if they please to the president. And think this is a very dangerous development. Thank you.
Mm-hmm. Thank you.
Roberto? So you are always the opener of the discussion, and then... yeah, very good.
Thank you. I would like to come back to the plurality of constitutional courts. As I understand, there are 85 subjects, but if I understand correctly, you don't have 85 constitutional courts. Okay. Now, does it mean then that it's not only the republic, but also the territories and all the sub-entities have a constitutional court? But then my question is, does each one of the 85 entities have a constitution? Because then I expect that each constitutional court is there to interpret and enforce their own constitution. And then, of course, the question comes naturally. What if there are inconsistencies between the 86th constitution or perhaps 85? I wonder whether the federal constitution is the 85th or the 86th. So how, and because there is no appeal to the constitutional court of the Russian Federation, and there may be inconsistencies among the different constitutions also within the same republic, it may be that there is no consistency in constitutional case law. So this would be my question. It seems to be really quite anarchical, and I doubt that there can be such an anarchical system in the Russian Federation. So how does it work? Thank you.
Let me reply. Concerning jury courts, it's a federal decision to create them, so subjects have no choice here as well. And that's true that the last jury court was created in Chechnya in 2010. By subjects themselves. They have no choice, but they have to create, and it means several organization procedures just to make lists for jury and to make procedures for choosing them and so on. But they could not make choice to create them or not. It's federal rulings. And examinations, it depends on the level of the judge. Because if you want to be a judge in highest courts, you have to go to Moscow and the examination will take place there. And if it's level of other courts, it can be also in subjects in their own examination commissions. Concerning Chechnya and murdering, I wonder the right question is, but you know, the court which will resolve this question, it depends on the crime. So which instance will be competent for this question? But I understand your question. It's difficult to say for sure that Chechnya is in legal order of Russia now. So it's a difficult political question. And its chair, who is Ramazan Kadyrov, he is very loyal to our president. So maybe there is no problems for punishment of such persons, and this situation is convenient for all sides in the Russian. And about appointment, what was the question? I see. 19 people. I see. You know, there is not the problem. Not the problem now, because you can appoint the people who are suitable for you, and you need not these tricks at all. Of course, you can manipulate this procedure. Yeah, but I think it's a question of responsibility. And there is no such crime in the criminal court not to appoint judges. And our president, he is responsible only for crimes. So there is no responsibility in the case of manipulation. Yes, it's an obligation, but it's an obligation, of course, and there are terms. There are terms for this obligation, but let us make next step. If you will not make your obligation, what else? So there is no responsibility for it, but no problem actually. And we have many real problems, not to think about hypothetical problems. And about constitutional courts. Our subjects, they all have constituent document. Republics have constitutions, and other subjects have what they call charter. But there is no difference besides the name, besides the title. So it's, for simplifying, I just call it constitutions. So every subject can create constitutional or charter court. and 13 are republics now, 13 from 22, which created, and one is federal city, St. Petersburg, and the other two are districts, which are territorial entities. So different subjects created. And the main problem with their creations, it's on the margin of appreciation of each subject, and there are not many cases for resolving. So the story I have skipped about the Chelyabinsk, you can know Chelyabinsk because of Meteor story a couple years ago, or maybe no. They have created a constitutional court, and after that they abolished, because they said, we have to pay them, and they have 3 cases a year, and it's too expensive for us. And constitutions of subjects, they can be reviewed by Constitutional Court of the Russian Federation. And there were a lot of cases concerning constitutions of the subjects. The most impressive cases were about sovereignty of the republics, because sometimes they have written in their constitution that they are sovereign, and our constitutional court said, no, you are not.
Just, if you allow a supplementary question, this concerns only the review of the constitutions of the subjects with respect to the Russian constitution.
Yes.
It's
sure.
not the interpretation of the constitution of the subjects, because now without a constitutional court in the subject, there is no court competent for it, because not with the constitutional court of Russia to interpret the constitutions of the subjects.
Yeah, but you know, there is 2 different kinds of interpretation, abstract interpretation and casual interpretation. And there is no abstract interpretation of constitution of subjects, but of course, when constitutional court consider them, he can give a casual interpretation. It's allowed for him. Okay?
John, you have a question?
Thank you. Perhaps not so much a question as an observation, but one which I'd like your response to in a way. Judicial appointment bodies have become a big thing in the UK. There are 3 actually. There's one for Scotland, one for England and Wales, and one for Northern Ireland. I should perhaps confess at this point that I did serve on the Northern Ireland board for 2 years, so I do have an interest in this. The purpose behind those bodies was to make the appointment process convention compliant, and also to try and increase diversity. But when in the course of your presentation, I was very struck by the sort of criticisms of the 3 appointment bodies in the UK coincide to some extent with the sorts of criticisms that you were mentioning in relation to your QC body. In other words, people complaining that they have to do exams. Well, it's just a public appointment. You've got to do something, you know. People complaining about the involvement of non-lawyers in it, which was a big feature, and several other things. So I'm just wondering about the fact that perhaps the purpose of these different appointment bodies is very different. But it's rather curious that some of the criticisms are the same. So perhaps if there is a question, why do you think the criticisms are the same? Is that just because people criticize always in relation to how resources are allocated? Why can't I have the job? But also perhaps what was the real purpose behind this kind of reform, if there was an articulated purpose behind the reform in the judicial appointment process?
Mm-hmm. So I can answer. You know, I think that the main cause for this criticism is the absence of transparent procedures. It's one reason. And another reason is recommendative character of decisions of qualification collegia. Because there was, as I know, a report of Venice Commission about appointment of judges, and they have said that it's no problem that the president will appoint the judges, but with strong more than consent of independent body of judicial community, for example. And it's not the situation like this in the Russian Federation. And we are not sure, maybe the qualification collegia by themselves are independent because their procedures are not transparent and their decisions, they can be appealed, but in most cases without success. And also there is only weak recommendation character of their decisions. So it's a good ban for candidates, and after that president can choose anyway. So that's why. I see that's right that it was like a criticism because it take another hour to tell about possible ways to resolve these problems. I know you cannot say, oh, it's a complete disaster and that's all. That's true. But you see there are some suggestions to improve the situation. But not about all problems, I can say that, because, for example, the difficult status of judges of the peace, it's a really strange thing when sometimes we remember that we are a federal state. And, of course, we can say, oh, we need some judicial federalism. And after that, we establish some courts of subjects, and after that, we say, oh, it's not the principle of equality, and let us make them more unified. And we make them more unified. And after that, we remember, oh, we are a federal state. And it's a kind of circle of a logic. And it's a kind of Zugzwang, because every pass makes situation even worse. And another answer is that the problems, they are not in the laws, and maybe it's even worse. Because to make things better, you haven't changed laws. You have to change practice. And it's much more difficult. So that's why.
Thank you. That was very interesting. Can I just two very quick questions for clarification? The first one is, I didn't understand after all this discussion. So what the Constitutional Court of the Republic, let's say, of the subject says, is that it, or is there another body higher up that is going to judicially review the decision of the court? This is the first question, just clarification. And the first issue, and the second question, not that in other states things are kind of much better, but where does international law fall into this? Is there any mention of international law? Is there any mention in the federal kind of law, or is there also mention in the laws of the republics? And do judges actually take into account, and do they refer to international law as a, if you want, a different legal system? Mm-hmm. Thank you.
Okay. Concerning the appellation, there is no possibility to appellate the decisions of constitutional courts of subjects, because they review the laws of the subject if they are not contradictory to the constitution of the subject. And it's not the question for the Constitutional Court of the Russian Federation. So no possibility to make appellation. And constitutional justice, it's not a system. They are separate, I guess, like in Germany. This was just like an example.
Mm-hmm. There is a possibility of a review if a person, for example, or the judge considers the constitution of the federation itself incompatible with the federal constitution.
Yeah, and this is the case, but it's not the procedure of appellation. It's
No.
just the new procedure before the Constitutional Court of the Russian Federation. Yeah. And international law, we have several articles in our constitution about international law. First of all, it's the Article 15, which said exactly that international principles and norms are part of our legal system. It's a very strong norm. And there are a lot of sophistication about what does it mean, really, but there is such a norm. And we have also Article 46 about judicial protection for citizens' rights. And there is several parts in this article, and Part 3 said that after exhausting all national remedies, yeah, you can go to the international bodies, and European Court of Human Rights. He's overflowed by our complaints. Yeah, that's true.
Stop.
And
Unfortunately, because we are in worldwide connection.
Yeah. What about the subjects? Do they actually, the judges in the republics, for example, do they refine any judgments to international law norms or imply international law norms, etc.?
yes, it becomes little by little a common practice to use international norms and also decisions, for example, jurisprudence of ECR. But here is also the question of division of competence between federation and subjects, because the questions of international communication, it's a question of joint competence, and it means that federation has federal law about these communications, and subjects must be in accordance with this law. So no political, in generally speaking, no political relations between entities and foreign countries, only economical, cultural, etc. questions.
There's a last question, if I don't see others, by Roberto, and then I have a small one myself, just for the pleasure of...
Yes, I suppose I'm tired because there's still something I don't understand. So I apologize and I swear it's my very last question today. I'm interested in the content, in the matters of all these other constitutions or charters or whatever. For instance, does the city of St. Petersburg, which I suppose will have a charter, has also a Bill of Rights for the citizens of St. Petersburg? This is my concern, you see. That's why I'm interested in whatever judicial system you may have that will ensure uniformity or the same quantity and quality of fundamental rights of citizens. So this is why I'm so interested, because if it is not, then it is really quite out of the mainstream to have different human rights in different parts of the territory of the Federation. Mm-hmm. Which, of course, you can articulate that a state constitution may have more rights than the federal constitution. Okay, but what if there are some big inconsistencies?
Mm-hmm. Well, subjects in their constitution, they can, of course, have this part about human and citizen rights. I cannot remember just now, and I wouldn't like to lie about St. Petersburg exactly. I need to check. But there are such parts in constitution, that's true. But the main position of our constitutional court was that the constitution in this part had to be interpreted in accordance with the constitution of the Russian Federation. So there could be additional guarantees And for example, it was a great case about educational guarantees, because according to the federal constitution, you have a middle level of education is a duty for children and for their parents to provide for. And Altai Republic, I think, make that not 9 classes but 11 classes are the duty for the parents to support. And Constitutional Court has reviewed this norm because it's not in strong consistency with federal constitution. And he said that, okay, it's possible to make additional guarantees. And you know, it's a difficult question, and you know why? Because we have Article 55, which said that human rights can be restricted by federal laws in such situations. And the question is, could it be laws of the subjects, not federal laws? It's not strongly prohibited, but it's not explicitly allowed. So it's the question. And if you make some additional guarantees for one person, you are at the danger to make some restrictions of a right of another person. So it was a question. But Constitutional Court, it didn't make it so deeply, so just additional guarantees, they are possible, and that's all, but not restrictions. And it's strong position. Only federal law can restrict human rights.
So maybe that's why there are so many cases that go to the European Court of Human Rights, because if there isn't one specific court that will confirm conformity, maybe that's why there are so much case law going to the European Court of Human Rights that plays the role, the substitute of a constitutional court, the way we, Supreme Constitutional Court, the way maybe traditionally it's been used.
You know, there are several causes because, for example, a lot of complaints in European Court are about enforceability of judicial decisions. So very often you have decision and no enforcement of it because it's not a job for judges, it's another problem. And there are a lot of such complaints, and there are already pilot decisions of European Court about it. Burdov II, this a great case.
So as always in a very interesting and good discussion, each question triggers at least 3 or 4 further questions, and so I use my authority as a speaker, as a chair, to stop here because we have arrived at the end of a long and interesting day. I renounce also on my question, which I had previously announced, and we can continue, those who want to, without the internet and without the microphones. And then there's organizational announcement to do, which is regarding the dinner. Unfortunately, we had to change the restaurant, but we have found another restaurant, and we will meet at, or the dinner will be at 8:30 in the restaurant Forst, which is, this is the good news, even closer to the hotel than the other one. And so we can meet at, I don't know, we can meet at 8:30 in the lobby because it's really 3 minutes walk from the... Yeah. No, it's also the restaurant part. So you can also have a pizza, but it's a free, yeah, it's also possible. So this is maybe a positive part, I don't know. We meet at, for those who don't know where the restaurant is, we meet at 8:30 in the hall of Hotel Academia and then go there. Others can join us directly there. I thank everybody for presenting, for discussing, commenting, questioning, and I thank Georgia Sartori for the logistical part, and especially also our student from the IT department, but she's a volunteer actually, who also helped us very strongly. You volunteered for this conference, so it's not a... Okay, so thank you very much, and see you at dinner, and then tomorrow for the second day of the conference.